Hello, good evening, and welcome to another session of Back to Basics. Today we are discussing Law of Torts. We have already had two sessions on this particular topic. In the first class, we looked at an introduction to the Law of Torts. We looked at the essentials, we looked at the characteristics, and in the second session, we started with discussing the general defenses under Law of Torts. We discussed the first four defenses under Law of Torts. And in today's class, the agenda is to discuss the next four defenses under Law of Torts. So let's begin with a very quick overview and revision of the previous two classes, and then let's get right into our agenda for the day. All right, so when you talk about torts, there are three essentials. There has to be a wrongful act, there has to be a violation of a legal right, and there has to be legal damage arising out of the act. When these three criteria are satisfied, a person is said to have committed a tort. Now, moving ahead, when you talk about legal injury, there are of three types. First is injury to person, injury to reputation, and injury to property. These are the examples which we discussed in the previous few classes. Let's proceed by talking about the list of general defenses. So we have already talked about voluntary non-fit injuria, plaintiff the wrongdoer, inevitable accident, and act of God. Today we are going to discuss private defense, statutory authority, necessity, and mistake of facts and law. We'll have a very quick overview and recap of the first four as well. So let's begin. So voluntary non-fit injuria, as we looked at in the previous class, is when a person suffers willingly, then no harm is done. Right? The person themselves consent to the harm. There has to be these four essentials which are met. The consent to the harm should be free. That means it should be voluntary. The person should have the knowledge of the risk, should have voluntarily accepted the risk, and should be having the decision making capacity. That means he or she should not be a minor or of unsound mind. Remember the example I gave you, that if you go and watch a cricket match and the batsman hits a sixer, the ball hits you, let's say, on your head, and you suffer an injury, you cannot claim damages. You cannot say a tort has been committed because you willingly put yourself to risk, knowing that watching a cricket match in the ground has a risk of getting hit by the ball. The exception to this particular defense is rescue cases. Okay. Now, moving ahead in the second general defense, plaintiff the wrongdoer. Now, what is a plaintiff? Who is a plaintiff? A plaintiff is a person who files the plaint or the complaint, or who brings action for the law of torts. And the other party is called the defendant, the one who defends the allegation. Correct. So, when the plaintiff himself or herself is the wrongdoer, then can they bring the action in law of torts? The answer is no. A person conducting wrongful actions cannot seek compensation for the harm or injury arising from the conduct. The plaintiff must come to court with clean hands. Now, remember, I gave you the example that if a person is, let's say, driving in the wrong side of a one-way road, and from the opposite side, from the right direction, a person comes who's drunk, and he hits the car of the first person who's driving on the wrong side. Can the person whose car was hit bring a claim of tort against the drunk driver? No, he cannot, because drunk driver, although he was negligent, although he was committing a particular tort, but this person, the plaintiff, was also in the wrong. He was driving in the wrong lane, and that is why he cannot go to the court and cannot claim damages. Or maybe if he can claim damages, he would not get damages to that extent. So that is the defense of plaintiff, the wrongdoer. This is also related to a maxim, extirpi causa non oritur actu, which means no action arises from an immoral or illegal act. Simple? All right. Let's move on to the third one, which we did in the previous class, inevitable accident. Simply an accident which cannot be prevented by ordinary caution, by ordinary care. So if you have taken ordinary precautions and you have the ordinary skill and care, still something happens which you could not predict by any means, which you could not prevent by any means, and that results in a tort. In that case, you can take the defense of inevitable accident. For example, let's say that you were driving on a road, and suddenly a dog came on the highway, and you pressed your brakes really hard and your car swerved and hit another car. Can you claim the defense of inevitable accident? Yes, because you exercised ordinary care, you pressed the brake, your car skills were up to the point. but still you could not control the car. You could not prevent that accident. You could not foresee that a dog would come suddenly on a highway. You were driving at normal speed and you hit the car. Now, in this case, if situations are different, let's say you were overspeeding, then that would not be an inevitable accident. That was an accident you could have prevented. If, let's say, your brakes are not functioning properly and you are aware of that, then again it would not be an inevitable accident because you did not exercise ordinary care or caution. So you need to be very careful about the facts in these type of cases. The fourth one, which we discussed, was act of God or vis major. Now, remember, I gave the example of the Oh My God movie where their lightning strike had striked on a particular shop which was destroyed due to that particular lightning strike, and the person filed a case on God. But yeah, when you talk about defense of act of God, this simply means that some damage is caused by a natural force. It could be lightning, it could be heavy rain, it could be earthquake, it could be tornado, tsunami, any natural force without human intervention. And another important thing which you have to keep in mind is the occurrence must be extraordinary and could not have been anticipated or reasonably guarded. So if you say that you suffered damage because of heavy rainfall and the weather department had issued a advisory or a warning that heavy rainfall would be happening in the forthcoming days, would you get the defense of act of God? No, because you could have anticipated, you could have reasonably protected yourself based on the weather department's warning. It was not an extraordinary event. But let's say it's an earthquake which was not predicted. In that case, you can claim the defense of act of God. So these were the four which we have already discussed. Now let's talk about the other four. The first one which we are talking about today is private defense. Now this is also a defense in criminal law. In tort law, this is a defense that allows a person to use reasonable force to protect themselves or to protect their property from harm. So to give you an example, let's say a person stops you on the road and runs behind you with a stick, a wooden stick. And in order to protect yourself, you pick up a stone and you hit, or you, let's say, show it to the person that you would hit him with that stone or a brick, and that person runs away. Would you be liable for assault, for creating a threat in the mind of that person that you would hit him or her? No, you would not be liable for assault because you were acting in private defense. You are using a reasonable force to protect yourself. So, no liability for assault. So, there are three, in fact, four essentials which you have to keep in mind when judging whether you would get private defense or not. Firstly, there should be imminent threat. That is, then and there, the threat should be present. For example, let's say if someone calls you and says that I will come and kill you tomorrow morning, is that an imminent threat? No, it's not. If that person comes tomorrow morning and you kill that person, that would not be counted as private defense because you had enough time to inform authorities. Instead of taking action yourself, or instead of killing that person, you could have informed the police. So the threat was not imminent. The threat was in a delayed, you could say, situation. Now, the other categories or the other criterias which have to be fulfilled are it has to be the necessary force, right? If using force is not necessary, then you would not get this defense. It should be a justified force. If it was unjustified, you would not get the defense. And it should be proportional. What do we mean by proportional? That only the amount of force which is necessary to avert that threat, to prevent that threat. To give you an example, let's take the same first wala case scenario that a person is coming behind you running with a stick, and you take out your, let's say, gun, which is a licensed gun, and you shoot that person in the head. Would that be counted as private defense? No, because the force you used was, not in proportion. He was planning to hit you with a stick, and you shot him in the head. You could have fired in the air to scare him away. You could have shot him in the leg to stop him. You could have shot him in the arm to stop him. But you choose to hit him in the head deliberately to kill him. So you would not get private defense because the force was disproportional. Okay. So this is the defense of private defense. Then the next one is statutory authority. Now, this is interesting. Statutory authority simply means that an action which is authorized by a statute. What is a statute? The law, right? Something which is authorized by the law and order no action will lie at the suit of any person for doing of that act. So if, let's say, a soldier uh, finds a person who seems suspicious of being a terrorist and that soldier kills that person with his gun, would that soldier be liable for the death of that person? No. The soldier is authorized by the law to protect the country, and his action would not lie under the purview of law of torts because he was acting under statutory authority. He was authorized by the law. And this is simply statutory authority. And when an act authorized by the legislature is done, this is an exception. Okay, there is an exception to this, that when an act authorized by legislature is done negligently, then an action arises. That means you have the immunity of not being prosecuted under law of torts if it is authorized by the legislature, but you cannot act negligently. What I mean by that is, let me give you an example. Let's say that you work in the bomb squad with the government. Okay, the government asked you to detonate a building, to blow off a building with a bomb. Let's say there are two buildings, building 1 and building 2, adjacent to each other. Building 1 is a warehouse where terrorist activity is suspected, and you are given the task of blowing up this building with a bomb. You are in the bomb squad with the government. Now you go ahead and, due to your own negligence, you blow off building number 2, which had residents living inside it, and those people died as a result. Would you be liable? Can you say that I was authorized by the law to blow a building? No, you cannot say that. You acted negligently. You blew up the wrong building. So you would not get the defense of statutory authority in that case. So this exception is important, that you cannot be negligent while acting under authority. Okay. Moving ahead to the next and final defense, which is the defense of necessity. That when an action is done to prevent greater destruction, the damage caused by that action would not be liable for law of torts. Very simple example. Let's say that there was a building, a series of building which were catching fire, and then in the middle there was a farm with crops, fertile crops. And there were more buildings ahead of the farm. Let me draw it once again. Let's say that this is building 1, this is building 2, this is a farm, and then there are more buildings here. 1, 2, 3, 4, 5. Building 1 somehow accidentally catches fire, and the fire spreads to building 2, and you notice it. And to prevent the fire from spreading to these buildings 3, 4, 5, 6, 7, you burn the whole farm and its crop so that the fire does not spread to building number 3. आप पूरा खेत जला देते हो ताकि आग आगे ना फैले, क्योंकि when the farm is burnt, the fire would not travel farther ahead, right? क्योंकि वहाँ पे जले हुए में आग कैसे travel करेगी. So you obviously caused damage to someone's farm, which had agricultural produce, which had crops, but you did it under necessity to prevent greater discussion, not discussion, greater destruction. अगर इन 4 बिल्डिंग में आग लग जाती तो और ज्यादा नुकसान होता, जितना सिर्फ एक खेत को जलाने में हुआ है उससे बहुत ज्यादा नुकसान होता. So ज्यादा नुकसान को बचाने के लिए you did this activity which caused damage to the crops and the farm, but you would get the defense of necessity because this was a voluntary act where you cause damage to prevent greater harm. Simple. Okay. One more, this is not a defense, this is more of an exception or a thing which you should know, that mistake of fact or mistake of law are not valid defenses in tort. In some cases of different laws, let's say contract law. In contract law, mistake of fact is a defense. You can say that you did not know the correct facts and that is why you're not party to this contract. But in law of torts, mistake of facts is irrelevant, that you did not know the fact that something was unintentional on your part. Intention does not matter in law of torts. If you commit an error in understanding or understanding wrongly, that is your fault. You cannot claim a defense that I did not know things correctly. Neither can you say that there was a mistake of law on your part, that you did not know the law of the country. आप किसी को मर्डर कर दो एंड देन बोलो मेरे को तो पता ही नहीं था मर्डर करना जो है इलीगल होता है. It does not work that way, right? So mistake of facts and mistake of law are not applicable in law of tort. So this is not a defense. This is a important point which I had to tell you guys. So we are done with all the defenses, the 8 defenses. Warranty, unfit injuria, plaintiff the wrongdoer, inevitable accident, act of God, private defense, statutory authority, and necessity. So technically seven defenses. And now we know that mistake of fact and law is not a defense. And that brings us to the end of this particular class. I hope this was productive. In the next class, we'll start with the different concepts of law of torts. We can start with assault and battery in the next class. So make sure you subscribe to the channel, like this particular video, and follow this series for more such interesting content. I'll see you all in the next video. Till then, take care. Bye bye. Signing off.